All right, well, good morning, everybody. My name is Stuart Gordon, Chair of the Residential Subcommittee of the Real Property Law Section's Residential Committee. Today is the third session of the 2022 Residential Seminar. And so hopefully you guys are able to log in for the first two. We had one in the middle of January and then one about 2 weeks ago. Recordings of those sessions are available on the section's website if you want to go back and view those. Again, typically we meet in person at the State Bar headquarters for an all-day event, but due to COVID, we're adjusting to these three online virtual sessions. And then hopefully next year, we'll return back to an in-person event for the residential seminar. A couple things to mention is thanks to Lane with the State Bar for helping get this thing organized. And he will coordinate the credit hours. So no need to send emails unless you don't think the credit was applied. The material was sent out via email. I believe it was last night or maybe this morning. So you should have that in your inbox. If you don't have it, then you can send me an email or post a note on the Q&A box, and we'll follow up on that. Speaking of that, on the screen, there is a Q&A prompt at the bottom, and that's where you can post questions for the panelists to go over. So coming up at 11 o'clock, we've got Ali Jet talking about quiet title actions. But first, next, we've got a presentation about eNotes and foreclosure of eNotes. And we've got three really good presenters here, Jane Bond, Marcos Posada, and Sharon Horskamp. And if you'll give me a minute, let me just give you some brief bios on all three. So Jane Bond is the managing partner of McCalla-Ramer's Florida Litigation Group. She has over 30 years of litigation experience, with 27 years devoted to business and real estate litigation involving the mortgage lending and servicing industries. She currently sits on the board of Legal League 100 and chairs the Legal League 100 webinar committee. Jane is a member of the State Bar of Florida, serving as a committee member of the Real Property Finance and Lending section. Marcos is the managing partner of McCalla-Ramer's Illinois litigation practice, based in our Chicago office. He concentrates his practice on real estate litigation and general contract issues concerning mortgage servicers, banks, investors, and various commercial entities. His practice includes FDCPA disputes, commercial foreclosures and litigation, appeals, state court litigation in residential real estate, or plebin, and creditor rights disputes. Then lastly, we've got Sharon Horskamp, kind of a guest appearance. Sharon serves as general counsel and secretary for Merce Corp Holdings, a mortgage electronic registration systems, which is a part of the ICE Mortgage Technology, a business segment of Intercontinental Exchange, a leading global provider of data technology and market infrastructure. She has been a member of the MERS team since January 1997, where she developed the legal needs of the company from the ground up as the corporation grew from a startup to being acquired by ICE in October 2018. She played a key role in gaining mortgage industry approval for the MERS system as the mortgagee of record as nominee for mortgage lenders, which has resulted in over 135 million mortgage loans registered in the MERS system. She's also the lead counsel on advising MERS Corp on eNotes in the MERS Registry. And I can say that with some refis I've done lately, there's definitely been eNotes that borrowers have signed, which is separate from the whole topic of Ron that's been a hot topic lately here in Georgia. So with that, let me turn it over to Sharon, Jane, and Marcos. To Marcos, go ahead, take it away.
All right, thank you, Stuart. Thank you very much. Let me go ahead and share my screen so that hopefully everybody can see our wonderful PowerPoint. Jane or Sharon, can you give me a thumbs up? Just let me know that you can see it. Great, all right. Well, good morning, everybody. And Stuart, thank you for that kind and very thorough introduction. As Stuart said, my name is Marcos Posada. I practice in the state of Illinois for McCalla-Ramer's Litigation Group, and just want to thank everybody for their time today. I know that everybody has plenty to do, and so we really appreciate it. Our goal is to give you the ins and outs of what eNotes are, the key terminology that you need to know when thinking about eNotes, in an effort to increase everyone's knowledge just a little bit, so that you can speak on them yourself. Why eNotes and why now? What we've seen primarily since the pandemic began was that everything and technology has really kind of forced its way into the legal system. And I'm sure everybody in the audience can relate to that, from, appearing virtually in court to, other methods of technology implementing into your day-to-day activities. Stuart touched on this a little bit, but eNotes have really taken off over the last several years. And I know personally I've spoken on this topic, and I'm very thrilled that Sharon is on our panel with us. She's by far the expert on eNotes. But just to kind of give you an idea of the popularity that eNotes have seen recently, I think as of February 2022, from what I saw, there was over 1.5 million eNotes registered. And there's obviously hundreds of millions of people in the country, millions and millions of properties. That may not sound like a big number, but when we look back just to 2020, when our firm first started presenting on eNotes, even back in 2020, it was still relatively rare. And statistically speaking, we saw 2020, the amount of eNotes climbed to over 400,000, which at that time was a 264% year-over-year increase from 2019, which is a pretty big jump. Then if you go back a little bit further, in 2018, there were only 375 loans registered on the eRegistry. So quite a big jump. It's definitely becoming more and more of a recognized thing in the financial services industry. And I will begin and give you some of the overview of what eNotes are. eNotes are an electronic version of a promissory note that's negotiable under Article 3. They're used by both Fannie Mae and Freddie Mac. And the Federal Electronic Signatures in Global and National Commerce Act, otherwise known as eSign, provides that eNotes are legally enforceable in all 50 states and the District of Columbia. The eSign Act, along with the State Uniform Electronic Transaction Act, otherwise abbreviated as the UETA, has been passed in 48 states, Washington, D.C., and the U.S. Virgin Islands. These two laws adopt the legal principle that electronic signatures and records should be afforded the same status as ink signatures and paper records. As I said, both Fannie and Freddie use eNotes, and these eNotes are created using the loan doc origination system from the original lender. And these are basically templates which include all the same language which you would customarily find on a paper note, such as interest rate and principal amount. There's also something unique about them, and there's generally a provision which includes something along the lines of the borrower agreeing that the electronic note will be enforceable and valid, stored in a manner permitted by the UETA or eSign, and that the authoritative copy of the note, of the eNote, will be the copy identified by the note holder after the loan closing. So when you think of an eNote, in comparison to what you're probably more familiar with in terms of the paper note, you should think of control and transfer of control instead of, more commonly with paper notes, possession and endorsement. So remember, control and transfer of control. And further on down in the presentation, I believe we have a really useful slide that has all the buzzwords that you may need to remember, kind of in a quick, like, one-stop shop. The person identified as the controller is equivalent to the holder of the paper promissory note. So the controller is equivalent to the holder. And kind of wrapping up the basics, the two defining characteristics, which everybody should remember as far as eNotes, are that they have electronic signatures and they are stored electronically. So if we move into my next slide here, we'll talk now about the authoritative copy of the eNote. Again, I mentioned when you think of an eNote, you think of control and transfer of control. You also need to think of the authoritative copy of the eNote. On this slide, I mentioned that under 7021 of the eSign Act, the authoritative copy of the eNote is one that is unique and identifiable. and subject to the following exceptions is unalterable. The few exceptions are that copies or amendments that add or change an identified assignee of the authoritative copy with the consent of the secured copy. Each copy of the authoritative copy and any copy of a copy is readily identifiable as a copy that is not the authoritative copy, that's a mouthful, and any amendment of the authoritative copy if readily identifiable as authorized or unauthorized. Many state UCC laws have adopted the same or similar standard. So a little bit more into the authoritative copy. It's comparable to the wet ink paper note. It's registered with the Mersey Registry, and Sharon's going to explain all about MERS and what the e-registry is in great detail. It's going to be very informative. The authoritative copy is comparable to the wet ink paper note registered with the Mersey Registry by the original note holder, aka the controller, after the tamper evidence seal is applied. That tamper evidence seal is applied immediately after the borrower's last signature has been applied to the note, and it makes sure basically that no unauthorized tampering occurs. The MERS e-registry stores the unique digital signature of the eNote, which is known as the hash value. Let's go on to the next slide. So what about the endorsement? I think this is one of the most commonly, the most common area, I think, with eNotes that causes a little bit of confusion at first, but it's actually fairly straightforward. Endorsements of eNotes is not required under the Federal Electronic Signatures in Global National Commerce Act, otherwise known as e-sign. And again, section 7021 of 15 United States Code talks about this. And it states, delivery, possession, and endorsement are not required to obtain or exercise any of the rights under this section. The appropriate electronic transfer registered in the e-registry system is the functional equivalent of a physical transfer with an appropriate endorsement or allonge. Slide. So wrapping up kind of the quick overview, obviously, I think hopefully everybody will agree that the volume in eNotes is going to be something that we continue to see rise. It definitely took off over the last couple of years since COVID hit. And I think, you know, Sharon will have a little bit more information as far as the statistics currently, but it's not slowing down anytime soon. States will vary based on custom and practice. We have a couple of states here as examples. Florida's been much more liberal using fully electronic closings, remote online notarizations, which was in effect prior to COVID hitting, whereas Connecticut has been historically much more conservative, requiring title insurers using wet ink signatures. So with that, I am going to turn it over to Sharon Horskamp. Sharon?
Thank you, Marcus. If you move on to the next slide here. So what is MERS? Stuart mentioned some of the different components of what makes up when someone says the word MERS. Oh, it's on MERS or call MERS. You know, we hear that word a lot, but what does it really mean? And it depends on the role that or the context of what you're talking about. There is MERS Corp Holdings, which is the company that owns the MERS system and the Mersey Registry. And I'll talk a little bit about the MERS system, more about the Mersey Registry, because that's the one that's the database where the eNotes information is. But it's the parent corporation of Mortgage Electronic Registration Systems, Inc. And many of you are probably more familiar with that component of MERS than the eNotes and the Mersey Registry. Mortgage Electronic Registration Systems, if you go on, Stuart or Marcus, to the next slide, please. Mortgage Electronic Registration Systems serves as the mortgagee of record as nominee for a promissory note owner. And I refer to that as MERS. And MERS, as the mortgagee on the mortgage or the deed of trust, is that instrument is recorded in the county land records. And what happens then is that the mortgage information is registered on the MERS system, which is a tracking system. It's not a system of record, and it certainly doesn't replace the public land records. Over the years, when I started at MERS 25 years ago, we didn't have any mortgages yet with MERS on. And then over the years, there was always a myth about, oh, well, MERS is replacing the county land records, or MERS does electronic assignments, and it doesn't. What the MERS system does, it's a tracking system, and it tracks the changes in servicing rights, and it tracks the changes in the beneficial note ownership. Before, it was just paper notes that we were tracking the changes of, and now we're getting into the eNotes. And MERS, as the beneficiary or mortgagee in the county land records, it gets service of process. It gets a bunch of mail. So in order for MERS to know where it has to send this information, you have the MERS system, and that's where the mortgage information is then registered with on the MERS system. I mentioned it's a tracking system. No legal interests are transferred on the MERS system. That's different than the Mersey Registry when we start talking about the Mersey Registry. So Marcus, next slide, please. Just a quick overview. And I just wanted to do a refresher for all of us on the MERS system and mortgage electronic registration systems before we dive into eNotes and the Mersey Registry. But how the MERS system works, and remember, when we refer to the MERS system, we're talking about the mortgage tracking system. We're not talking about the eNotes and the Mersey Registry. So it's important that as you move forward, when someone says the MERS system, you understand what the MERS system is. And when someone starts talking about eNotes and the Mersey Registry, what the Mersey Registry is. Two different databases that MERS Corp owns and runs. So on the MERS system, you would have at the closing, the borrower is going to sign the mortgage or the deed of trust and a promissory note. As I mentioned, historically, paper promissory notes. As we're moving forward, we're seeing the notes are now eNotes. MERS is appointed mortgage electronic registration systems. That's a sole purpose of that company is just to be the mortgagee. MERS is appointed as the mortgagee as nominee for the lender, its successors and assigns. It is recorded in the county land records. As I mentioned, MERS is not seeking and does not legally replace the recordation to perfect the interest in the mortgage lien. So the security instrument is always recorded in the county land records. The lender then registers that loan information on the MERS system. If the servicing rights are sold, and servicing rights are a non-recordable contract right by a purchase and sale agreement. So if the servicing rights are sold from one servicer to another, then they still have their non-recordable contract legal transfer that's occurring, and the MERS system is tracking who the old servicer was to who the new servicer was. If the note is sold, and the note, how that gets sold, we know under the UCC when we talk about paper notes, endorsement, and delivery, and we'll talk about how that changes with the eNotes. That's how you sell a note. Nothing is occurring on the MERS system. So when the note is changing hands, then the MERS system is updated to let us know who we're now the agent for. Who are we the nominee for? We have to know who we're working for. And that's the purpose of the MERS system, so that we know who the current servicer is and who the current note owner of the note is. The lender, there's no breaks in the chain of title. There's no need to do any mortgage assignments because MERS as the mortgagee is tracking these non-recordable changes, and MERS as the mortgagee starting on the security instrument is immobilizing the mortgage lien in MERS's name. There's nothing legally that says that when servicing rights are changed or when a note ownership is moving, the mortgage lien has to move. You can have it's simple agency principal relationship, and that's why the MERS system works the way that it does. Anybody can call the MERS system and find out who the current servicer is. The borrowers can certainly find out who their investor is. And that was another myth we heard over all these years. Well, how are we supposed to know who we're supposed to go to? We would hear that from borrowers a lot in foreclosures. I didn't know who I was supposed to pay. As we know that there are federal laws, the hello goodbye letters under RESPA, under TILA, when the notes are sold. There's also information that goes out to the borrower on those transactions. The MERS system is not the system of record that tells people about that. It's a tracking system. So Marcos, if we go to the next slide, please. So MERS system and Mersey Registry by the numbers. We're currently up to 136 million plus registrations on the MERS system. We average about 15,000 to 20,000 a year. Perhaps in 2022, we'll see that go down just because we're seeing the market as a whole go down. There's 5,000 plus members that use the MERS system. On the Mersey Registry, far behind, right? We're at almost 1.6 eNotes, but that is gaining traction as it goes on. It's roughly about 5 to 6% of the total registrations that we're seeing. eRegistry came online in 2004. In the early days, the only game in town to sell eNotes was to Fannie Mae and Freddie Mac. But as we've been seeing over the years, many other investors are getting involved. You have the Federal Home Loan Banks now who are allowing eNotes to be put into their collateral, as well as Ginnie Mae has their pilot program going. So we're seeing more and more outlets, as well as warehouse lenders. The warehouse lending industry has come on board. So those were all critical components that it wasn't just up to the originators to say, oh, you know, I'm ready to do eNotes. They needed an outlet. They needed a place to be able to sell these eNotes. And so we're starting to see the full cycle of from start to finish where the eNotes can go. There's roughly about 64 lenders who are actively originating eNotes, but there's many more who have dipped their toe in the water, if you will, and at least have done one or two, because there's things that they have to do operationally to get themselves up and running. But every day we're seeing more and more lenders, warehouse lenders, investors showing their interest and wanting to get integrated to start originating the eNotes. Next slide, please. So eNote month over to month growth. You can see this is just a snapshot of 2020 through January of 2022. But if I had put a slide in here that showed you the early years, you would have seen just a very slow growth as it was going. And I do think that with the pandemic and unfortunate circumstances, but that certainly did increase the volume of eNotes that we're seeing. So if we go to the next slide. Okay, now we're going to get into the heart of eNotes and what does it mean? Marcos had mentioned the word control. Control is key to an eNote. We like to call it that there's really an ecosystem. I'm here talking about the Mersey Registry, but the Mersey Registry is just one component of what is needed for everything to work together to be able to say that you have control of an eNote. So all of this comes together. If there's any one weak link, it's very possible that if somebody has an eNote, they're not going to be able to show their control. And an eNote, having control of an eNote is the key to its worth. You want to be able to enforce it. You want to be able to sell it. So that's why we've put this slide together to just make sure that everybody understands it's not just talking about the Mersey Registry. It's not just talking about the e-commerce laws. It's everything that is taken together. And in fact, the e-commerce laws, and Marcos had talked about UITA and eSign, that statute, those laws actually do use the word system. They talk about to have control, you have to have a system. And then how do you, what does this system have to do? And there's 6 components that's called a safe harbor. We're not going to delve into that here with all of the details, but if you get a chance to take a look at eSign and UITA, and you look at the 6 components of saying, okay, if I have a system, what does this system need to do? There are 6 components within that give you guidelines. And if you meet those components, you'll be able to show that you have control. So you've got the e-commerce laws, you've got eSign and UITA. Very important to understand those two, because that gives, those really are the guidelines of what it means to have an eNote and what it means to have control. There's eNote language. We had mentioned earlier that there is a uniform Fannie Mae, Freddie Mac form of an eNote where it has language in there. Typically, you're going to find that in paragraph 11. I've seen it in paragraph 12, but it includes specific provisions that addresses the electronic nature of the note. It also has the necessary consent that a borrower needs to give, that they're agreeing that this is a transferable record under eSign and UITA. And it also references the Mersey Registry, that it does say, if you want to know who the holder of the eNote is, then go to the Mersey Registry, and the Mersey Registry will identify, and the party that is identified as the controller will be considered the holder. You have investor requirements. I had mentioned that in the early days, Fannie and Freddie were the only game in town. And now you have the Federal Home Loan Banks. There's Ginnie Mae. Warehouse lenders have their own requirements. And so you have to watch out what the investor requirements are. The originators have to know, okay, if I'm selling into Fannie and Freddie, what do I need to have in my note? What do I need to have for my eVault? How do I store my eNote? When do I do my transfer of control? So the investors have a say in what's going on here too. You have e-closing platforms. The e-closing platforms are where the closing typically is going to happen. They have to have the technology and the protocols set up to be able to fulfill the e-commerce law's requirements of what is an electronic signature. How do I know that it's secure? How do we show that the proper intent to electronically sign was done? So the e-closing platforms are very important. And also in the e-closing platforms, Marcos had mentioned about the tamper seal, the digital signature or hash value. It's all the same term. I've heard it used all those 3 different ways. And at the time after the borrower electronically signs, the eNote is tamper sealed. It has this digital signature hash value. It's like a shrink wrap around it, so that Marcos had mentioned, you have to be able to not have any alterations without detection. That's what that tamper seal is going to do, so that if anything gets changed in that eNote and you recalculate the tamper seal, it's going to be different than when the borrower had signed it. And that's a key that maybe something has changed. eVault providers, again, very important component. The Mersey Registry does not store eNotes. We don't have the eNotes. The eVault providers are going to have the eNote. They have to have the protocols in place to be able to show this copy of the eNote at this point in time is the authoritative copy. Sometimes that can be a watermark. Sometimes it's a control number. So the eVault providers, key to all of this, the eVault providers are also communicating with the Mersey Registry to let the Mersey Registry know about various transactions that happen. And then of course you've got the Mersey Registry. Mersey Registry is the database that is going to identify the entity that has control. And it also is going to identify the entity who is maintaining the authoritative copy. And we're going to get more into detail because I know I've thrown a lot of terms out there, but hopefully as we move along with these slides, it will all come together. So if we go to the next slide. So what is the Mersey Registry? I had mentioned that it's it identifies the controller and the location, and it's the centralized registry that the mortgage industry has agreed to use to identify the controller and the location. And that's why in the Fannie Freddie uniformed eNote, they do mention the Mersey Registry, that, and the investors also, I mentioned investor requirements. Investors put in their guidelines, put in the Mersey Registry, and it has to be registered on the Mersey Registry. And that is the place where we will do our transfers of control. That is the place where we will do our transfers of location. And as the difference between the Mersey Registry MERS system, as you remember when I talked about the MERS system, I said that's a tracking system. It is a tracking system that is telling us what has occurred outside of the MERS system. On the Mersey Registry, the transfers of control is the actual transfer of the interest, the legal interest from one controller to another controller. So if we go to the next slide. So a very high level eNote process flow. You're going to have the eNote generated by the eVault or the e-closing platform. I distinguished it before saying that the e-closing platform is where the closing will happen, but there are some eVault providers where that's a blend of a platform. So it can either be at the eVault / e-closing platform or vice versa, but the eNote is going to be generated because it's a smart doc. And so that's where that's going to get generated. The borrower is electronically going to sign the eNote. Again, the e-commerce laws control, I'll use small c, control what is required for a valid electronic signature. After that's electronically signed, that's when you're going to have the eNote is going to be tamper sealed. It's going to be shrink wrapped, if you will. So it's a thumbprint. Any changes to it will be detected. Remember, key. It has to be unique, identifiable, and unalterable without detection. Those are 3 things I mentioned. There were 6 components of the safe harbor. That's one of them. The eNote is then stored in an eVault. Again, no eNotes are in the Mersey Registry. That's something we hear a lot. Well, the eNote is with the Mersey Registry. No, it's not. The eNote is not with the Mersey Registry. It's going to be with an eVault provider. The eNote is registered on the Mersey Registry. When I say that, it's the eNote information is going to be registered on the Mersey Registry. I can't say it enough. No eNote stored at the Mersey Registry. Copy of the eNote is sent to trading partners versus a product called MERS e-delivery, because you have to be able to get copies of eNotes from one place to another. And I'm going to talk more about that, because sometimes people can have an understanding of, oh, well, there's one eNote and I'm just sending it along and now I don't have it. Not so in the electronic world, right? And we're going to talk more in detail about that. But the copies of the eNotes have to go to the partners that need to have a copy of the eNote. And then the authorized rights holder positions for the eNote record are transferred on the Mersey Registry. Transfers of control is a transaction we have, as well as transfer of location. Those are the key fields on the MERS e-registry. If we go to the next slide here. All right, so this is a refresher for all of us, because I think it's always good to go back, because one of the key things about an eNote is that it would be a paper note if it were in writing. Well, okay, well, let's try to remember, right, everybody, what the paper note has. A paper note, promissory note, negotiable instrument under the UCC, it's a written document. So already, right, we're not going to meet that with an eNote, but it's signed by the maker. It contains an unconditional promise to pay a certain sum of money on delivery or at a definite time. So, but for it being in writing, the eNote has to have those other qualities. Sometimes people will ask me, well, what about HELOCs? HELOCs, not going to be considered a transferable record, because it's not always a sum certain that has to get paid. So HELOCs, many times, now there's some case law goes either way, but right now we're not seeing any HELOCs being done as an eNote, because an eNote is defined in the e-commerce laws. They use the word transferable record. Industry says eNote, but it has to be considered a negotiable instrument under the UCC. And but for the fact that it's electronic. And HELOCs, many times we've seen some case law that says it could be, other case law says it's not. So right now HELOCs are not considered transferable records. Paper promissory note, transferred by endorsement, delivery, and possession of the note. How are we going to do that in the eNote world, right? And that's where we're going to get into what happens, how you show endorsement, delivery, and possession, and what those key words are. So characteristics of the transferable record. We call it eNote. E-commerce is going to call it transferable record. Same thing. It would be the note under the Article 3 of the UCC if it was in writing. There has to, the issuer, borrower, has to expressly consent that it's a transferable record. And that's why the language that is in the uniformed instrument that Fannie and Freddie has out, that Federal Home Loan Banks have adopted, Ginnie has adopted, has that critical provisions in paragraph 11, could be paragraph 12, commonly paragraph 11, has that needed language in there, because it's critical to have that language in there. Otherwise, you will fall short of the e-commerce laws. You will not have a transferable record. As Marcos had mentioned, delivery, possession, and endorsement are not required. Well, okay, then how do I show this? So let's go to the next slide here. Term sheet. All right, we've gone over, I think, a lot, right? Negotiable instruments. We all have our refresher on that. We understand what that is. That equates in the electronic world to a transferable record. That's the words that the e-commerce laws use, but we'll refer to it as an eNote. In the paper world, you have an original note. You have the borrower who has signed that original note, and I can hold it. I can give it to somebody, and you can see on the face of it that it's the original note. In the e-commerce world for eNotes, you have what's called the authoritative copy of an eNote. And let's think about that, right? If I've got an electronic document and I go to email it to you and I attach it to my email to you, I don't get rid of the document I have. On your end, you're going to now have a copy of it. It's going to be electronically transmitted. So now we have two copies of an identical document. So who distinguishes what? How are we going to know in the eNote world who has what? And that's where the authoritative copy of the eNote is going to come into place. So it's not that there is one eNote that is going to get passed around from person to person. It's an impossible thing to do in an electronic world. You will have, the more times I pass that eNote around, the more identical copies I'm going to have, but only one point or only one of them at a point in time will be the authoritative copy of the eNote. And that's where the eVault provider comes into play, coupled with the Mersey Registry, telling you what party is maintaining at that point in time the authoritative copy. In the paper world, I can have possession of that original note. In the eNote world, I have to show control. Mersey Registry is part of that eNote control ecosystem, as are all those other components. Paper world, I'm called a holder when I have that paper note in my possession. E-commerce world, or eNote world, I'm going to be the controller. Paper world, custodians, original paper note, right? It's an asset. It's got value. Who is ever holding it has the rights to enforce it. Until proven otherwise, they have the rights to enforce it. So paper promissory notes in the mortgage industry are held with custodians in vaults, because you certainly don't want to be having them float around. In the eNote world, it's going to be the location, an eVault provider. So similar, right? You've got a vault, a custodian who has a vault for the paper notes. eNote world, you're going to have eVault providers who are going to have the authoritative copy. Endorsement and delivery in the paper world, transfer of control in the eNote world. Chain of endorsements and deliveries, that's showing from one holder to another holder to another holder. eNote world, on the Mersey Registry, there's a transferable record audit trail. That is something that Jane will start talking about when we talk about enforcements, because you're going to have to print that off to be able to show that it moved from one controller to another controller to another controller. Paper world, wet signatures. eNote world, you have the electronic signatures. So next slide, this is an illustration of what I was talking about within the eNote world, right? Many parties are going to have identical copies of this eNote. It's going to start with the originator, but the warehouse lender is going to want to have a copy. The document custodian will want to have a copy. The investor will want to see a copy when they're doing their due diligence. And so I'm transmitting a copy of my eNote to the investor so that they can make sure that this is a note that they want to buy. Master servicers have to have a copy of the eNote. And then sometimes there's a party called the secured party. Typically, that's going to be a Federal Home Loan Bank or Ginnie Mae. There is a field on the Mersey Registry for a party that's called a secured party. And that's someone who has sold, pledged, or signed, or has an interest in an eNote. So if we go to the next slide, this is where, it doesn't look like it came up on the slide here, but this is where you'll see the Mersey Registry on the bottom, and then there would be lines that would be going up to the originator, showing that the originator at this point in time is the controller and location of that eNote. So I apologize for that. I don't know where those lines went, but if we go to the next slide, hopefully the lines are showing on this slide. Marcus, can you go to the
Marcos, keep clicking on that slide because it's doing something with highlighting copy of eNote.
Oh.
There you go. There's some of your, for some
yeah,
reason.
okay, yeah. So I don't know what happened on the screen there, but the first slide would have shown that the originator was in the controller and location field. The slide before this one would have shown that there was it doesn't have all the lines here again, but it would have shown that the originator selling the eNote to the investor, there would be a transfer of control and a transfer of location. So at this point in time, the Mersey Registry would be showing the investor in the controller field and would be showing the investor in the location field. Sometimes a document custodian may also be in the location field, but this was just a simple workflow. So hopefully on the slides that were sent to you listening out there, you do have the lines. If you don't, feel free to contact me and I'd be happy to send you those slides. Okay, so looking at the time, so I'm going to breeze through these. I've covered much of this already, but the Mersey Registry with the eNote registration, the eNote is going to have it is a smart doc. GSEs have the uniform instrument eNote provisions. Those Jane will mention when she starts talking about foreclosures. eNotes have been foreclosed. They have these provisions in them and they have successfully been foreclosed. On the eNote, there also will be a mortgage identification number, which is a unique identification number to the MERS system and the Mersey Registry, electronically executed, and then it will have that hash, key to have the hash. The eNote is stored in the eVault and it's registered on the MERS eRegistry. So just quickly, if we'll go here. So if you were to print out an eNote, different from convert to paper, I'm not going to get into convert to paper, but I'm happy to have that conversation with anybody that wants to follow up with me. What does it mean to convert to paper? Whole nother topic. So I won't spend the time here, but if I was to print out a rendition of my eNote and it's staying in an eNote form, this is what the top's going to look like. This is how you're going to know it's an eNote. It's going to say note and it's going to say for electronic signature. You see the min that's there. That's our tracking number. And if you go to the next slide, this is parts of paragraph 11 that I was mentioning. Paragraph 8 is the express consent that the borrower is saying, yep, I agree. eNote, UITA and eSign is going to control. And then paragraph B is going to say, and who's identifying the note holder is the registry maintained by MERS Corp Holdings. So again, there's at least, I think it goes through paragraph E. I only took these excerpts here, but take a look if you get a chance to see the Fannie Freddie uniform instrument and read through paragraph 11. It also talks about convert to paper. Again, not talking about that here, but that's certainly an interesting hot topic right now that many are talking about. All right, so if we go to the next slide, this is just an explanation about the min. You can browse that. Min is critical on the MERS system as well. Every recorded document that Mortgage Electronic Registrations is on does have a min, as well as eNotes have the matching min if it's a corresponding MERS's mortgagee recorded security instrument and an eNote. Both will have matching numbers. And the next slide is just talking more again, if you want to learn more about the digital signature tamper seals, there's information on here and how the registration happens on the MERS system. The next slide just is an overview of the role of the eVault. Very critical partner to us. We work very closely and integrate with the eVault. It's the eVaults who are talking to the MERS eRegistry and telling us what's going on. And remember, it's the eVault who has the authoritative copy. So when we get into the foreclosure discussions, it's the eVault providers are the ones, if it's ever called into question, hey, how do we know who had the authoritative copy? Or how do we know which copy was the authoritative copy? That's going to be the protocols that the eVault providers are going to have to be able to prove. And so we work a lot with the eVault providers in that area. And then if we just quickly go on to the next two slides, again, just telling you the functionalities that an eVault has to have, a critical player in all of this. And then lastly, I'll just show if someone was interested, well, what does an eNote record look like at registration? You can see we've got the min, tells you the eNotes is active, when it was registered, it's got all that type of information. And then at the bottom, it does have the tamper seal date. It tells us when it was tamper sealed. Typically, as I mentioned, that's within a couple seconds of a borrower electronically signing it. It gets tamper sealed right away. And then the last slide, you can look at that after I won't spend any time on that, but these are just the various fields that are on the Mersey Registry. And if you were a rights holder in that field, what is it you can do and who typically will be named? So sorry, Jane, I was trying to get all that in and still leave plenty of time for our default discussion. There was just a lot to get to.
Okay, let's move on to the next slide. Enforcement of an eNote. Well, Sharon and I were on another webinar recently, and I said that I went to a closing. This is why I am a big proponent of eNotes and eMortgages and e-closings all the way around. But what did they give me? A blue ink pen. Just like I got 30 years ago when I closed on my first house. So it took time, it took effort to get there. Some of you are probably in this industry and you know what a closing entails. Sometimes you don't have the papers ready. Sometimes you sit there for an hour. It's so nice to be able to click on your phone or click on your computer through the documents, especially we have investor clients who buy commercial and residential properties, single family rentals. and they would love to be able to be anywhere in the United States and just sign the documents. You usually sign into a secure, like DocuSign is one. There's many others, and you go in and they put almost like a Post-it note place that says sign, just like if you still are signing your documents in your office and not e-signing your pleadings. They tell you where to sign, and you click next and they tell you where to sign, and the whole document's there so you can view it and read it. Next, 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 you click, 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 you get through it. And many times, if you're pretty knowledgeable about what are in those records, it can take you, 5-10 minutes, since many of them are standard documents, to go through a closing. I prefer it. I would love to see the whole industry move toward e-signing. I know many are uncomfortable with it, but I think, the generation coming up is going to be more apt to want to e-sign because they're more comfortable with it. So what about enforcement? Well, in a judicial state, we need the original documents. Florida is a judicial state. You may not be in a judicial state. Georgia is a non-judicial state. So non-judicial foreclosures are generally unaffected. So when would you need to use this? I think it's just good to be knowledgeable. You never know when the power of sale clause will be left out of your document for some odd reason, and you're going to have to judicially foreclose, or if you want to enforce a note. You may have clients that have unsecured notes that you need. So even though I'm talking mostly about foreclosure judicially, think also in the realm of enforcing a note without any collateral behind it. Next slide. So in an original document state, or if you're ever going to have to prove your note and prove your mortgage and prove, your debt, you need the original documents in a state such as mine, not in your state, but you may need it if you're going to do a suit on note. But an e-note is legally enforceable in all states. The e-sign law is a federal law applicable to all states. UETA, most states have adopted UETA, and I'm going to tell you what your statutory section is in a second in Georgia. For evidentiary purposes, it should be treated the same as a promissory note, a wet ink signed promissory note. So right to enforce, as we've heard, you have to have control of the e-note. The controller is the one who has standing to sue and the right to enforce. Many states have adopted UETA, and these are the statutory sections in the states I've listed. However, Georgia, were you the first one to adopt UETA? Many of you probably already are saying, no way, Georgia is never that advanced. And you would be correct, because Georgia was the 47th state to adopt UETA. It's in the official code of Georgia, section 10-12-1, and I think it's 1 through 20. You may want to read through that sometime just to see what your state has to say about it, but it really pretty much went through the Uniform Act and took it as written. Electronic records and signatures are recognized under Georgia law. If the law requires a writing, such as the UCC, as Sharon was mentioning, or the statute of frauds, your electronic record satisfies the law. If a law requires a signature, an electronic signature is satisfied under Georgia law. And as you read through it, you will see that for the most part, even a copy of the authoritative copy, which is considered a tangible copy in most states, is looked at as the original for evidentiary purposes. Next slide. And here's why whoever has control has standing to sue, and the person has control if they've employed a system for evidencing the transfer of the interest, which Sharon went over in detail how it works on the eMers registry. So the eNote registry, and it also goes on to say if you need to identify the person entitled to enforce a note, you can go to the eNote itself. If it's never been transferred, the eNote itself will usually say, who the controller is. Or if it has transferred, you can go to the recording registry, which MERS is an example of, and it will show who is the transferee and who's the transferor. Next slide. So if you're going to file a complaint, what documents do you need? This is more the practical side. You're going to need, of course, as always, the original documents, a copy of a mortgage, and the authoritative copy of the eNote. Or in many states, as I've said, it's going to be a copy of the authoritative copy. You're going to have to look at your state and exactly what they require. A tangible copy of the record is considered in many states the original. Copy of the MERS e-registry. Sharon showed an example, the front page. I'm going to show you an example after this slide of the transfer page. If needed, if there has been a transfer, you're going to need the records of who the controller is. And many of our clients now are uploading certificate of authenticity, and sometimes we include those with our complaint, which just says they're the servicer of record. They have an e-vault, and in that e-vault is stored the authoritative copy of the note. Next slide. Here's a picture of what the Fannie Freddie single family document looks like, the eNote. And it says right at the top, it says note just like any other one would, but underneath it, it says for electronic signature. And the last page I put on there because it says electronically signed by, and it'll have the borrower's name written in, and then whatever seal they've chosen. And it might just be their signature in cursive writing. It might be some of the platforms allow you to sign your own name. However you determine or the borrower determines to put their name as a seal is what is there. Next slide. And here's the registration information. This is, I think Sharon referred to it as the front page or the cover, the first page, but it does list who the borrower is, who the controller is, who the servicer is. These should be current and up to date. When you receive a referral from your client and they want to sue in their name, you better be looking at who's listed as the controller and compare this document with who your client is and who they're saying to sue. There's also, sometimes servicers have contracts, and some servicers sue in their own name, some don't. So you just really need to line it all up so your plaintiff's name is correct if you're suing on the note or if you're trying to foreclose judicially. What else I thought was interesting is the MIN number that Sharon mentioned. When they close those and they're registered by the originator, they get the same MIN number. The note and the mortgage for that transaction with that specific borrower will have the same MIN number. The mortgage will in the e-mortgage registry, and the note will in the e-registry. So it's nice that they have the same number, and it's another evidence if you have the note and the mortgage and you need to show of that the numbers match and are comparable. Next slide. And here's the MERS eNote transaction history. And what you have here is one that was registered in 2008, the transfer of control and the transfer took place, and it shows on which date that happened, and then it transferred the servicer. And in this case, in 2010, the servicer was transferred, and it transferred into the servicer's name to be able to foreclose, and that was the reason actually for the transfer. So many times it may be done at the time of default, but it could be done before that, at the date that it actually transfers from one servicer to the next. Next slide. Admissibility of evidence. There's been a lot of confusion around how can these notes, and you can just hear when Sharon talks about many copies of the note at origination going out to several different parties. How do you know which one is the actual authoritative copy? But there's only one authoritative copy which is kept, and that's kept in the e-vault of the servicer. Once it is transferred to a servicer, it is actually sent to the new servicer and decommissioned in the old servicer's vault. So there are standards for that. Fannie and Freddie have standards for that. So I'm not going over that today, but you might want to look at that if you ever have any confusion or that comes up in some kind of defense in your case. But there's standards for the vaults of each servicer, and Freddie and Fannie have specific recommendations and requirements for the vault holders, which is audited. If it's an uncontested case, and we know most cases, most loans actually in the United States remain they're paying their mortgage. They're still going through and every month paying their mortgage, so we have no problems. And that's probably 90 to 95% of the cases. We have very low number of cases in default. And currently, it's going up a little bit because of the forbearance agreements ending. But for the most part, that isn't an issue. So for many of our cases, they aren't contested either when we receive them. It's a very low percentage of cases that become contested in our offices. So most of them go to summary judgment. And if you have the standard of the federal standard, it'd be a genuine issue of, it would be the preponderance of the evidence standard. But if you're in the old standard, like we were in Florida until this year, it's a genuine issue of material fact. So by affidavit, you're going to show that you meet all the requirements of the controller, and you're going to include any affidavit that you need from the servicer and the amounts due, and present them to the judge. Now, what if it's contested? Well, an eNote is considered commercial paper in the federal rules, and it's self-authenticating. So we follow the federal rule in Florida. Many states do follow the federal rule where an eNote could be self-authenticating. There is no case law on that right now, and so it's going to take some time. Probably the best way to get this evidence in is through the business records exception, saying that the servicer has this as their business record and they rely on it in the ordinary course of business. If you may have to have, because you're in trial, a witness come and testify, and that's fine too. So you would have the witnesses' affidavits and testimony. Case law to date, we have 3 cases, one in Indiana, one in New York, and one in Florida. For the most part, they were standing questions, and the foreclosing party did not include the correct MERS documents. In all cases except one, it was found in favor of the lender servicer, and the mortgage companies were able to foreclose these mortgages. But the Indiana case needed a little bit more evidence, so it was remanded. And it was basically because the MERS document were not included. So pleading correctly and including the correct documents with your complaint is very important in getting what you need out of the foreclosure and getting your judgment entered. I added some helpful hints here. The biggest one is education. Keep educating yourself in this arena. Read your state e-sign, the federal e-sign law, the UETA, know your state law, but education for the judges will be key. And with that, here is our panelist contact information. If you have any questions, I hope this was helpful for you today, and we will give it back to Stuart.
Great, thank you, Marcos, Sharon, Jane. A lot of good information. I really appreciate it. That was a really thorough explanation of the MERS system, so definitely thank you for that, Marcos and Jane. Thank you. And one of the benefits, I mentioned before that I wish we were back in person, the all-day event at the State Bar, but one of the benefits of having the webinar set up is we can invite people from out of state who may not be able to attend otherwise. So thank you to Marcos, Jane, and Sharon for logging in from where you might be. Definitely appreciate it. Okay, so we're at 11 o'clock, and the next session is about quiet title actions, and we have Ali Jett. Ali Jett is a fellow member of the Real Property Law Section Executive Committee. She's a founding partner of Jet Law Group. A couple things I'll mention about Allie that are noteworthy is that she is one of those double dogs, having gotten her bachelor's degree in linguistics and classical culture and her law degree from Georgia. I'll have to ask her sometime later what linguistics and classical culture might be. I really don't know, but it sounds really interesting. Allie started her real estate career at age 16 in the Cobb County Deed Records room, where she was running titles for her family's mortgage business. And she continued working in various capacities for that mortgage company until entering law school. She's admitted in both Georgia and South Carolina and has been named a Georgia Rising Star by Super Lawyers Magazine every year from 2012 to 2018, and a super lawyer from 2019 to 2022. So with that, I will turn it over to Allie Jett. Take it away.
All right, thanks, Stuart. Appreciate it. Good morning, everybody. I was, during our earlier presentation, I was scrolling through some of the participant sections and seeing a bunch of names of friends there. So I'm happy to virtually see those, a little regretful that I'm not seeing you in person, but hopefully looking forward to seeing some folks in person at the Real Property Law Institute in Hilton Head come this May. Also super happy to be presenting. I have been in Stuart's chair for the last couple of years, chairing the title standards seminar that we have every November. And so I have taken a back seat to doing any presenting myself. So it's kind of fun to get back to doing some of this. So as Stuart said, I'm here to talk for the next hour about quiet title actions. We are among the very many number of title curative actions that are out there. So let me just start by sharing my screen for my PowerPoint. Real quick and get that set up. Okay, hopefully all of that is working. So the title of the presentation today is Quiet Title Actions, Process and Substance. Let me see here. There we go. So this, like I said, like I alluded to a few minutes ago, there are many types of curative, title curative litigation or real estate related types of litigation that those of us who are the litigator members of the real property section might employ to cover a variety of title or otherwise real estate related disputes. We are here to really only talk about conventional quiet title actions and quiet title actions against all of the world. I think that's more than enough to even get kind of a cursory overview in an hour. So we are not going to be delving in deep into reformation actions, partitioning actions between heirs or other co-tenants, declaratory judgment actions, which I'll note briefly have a fairly extensive overlap with items that can be covered in a quiet title action could also be covered in a declaratory judgment action. I might highlight that in a couple of places, but we're not going to really talk about the process of a declaratory judgment action. Similarly, there may be a lot of claims or multiple counts in a lawsuit that involve title that may have some additional other forms of relief or maybe even tort-based claims. We're not going to be getting into things like ejectment actions or trespass claims, condemnation or inverse condemnation actions, and we're not going to be talking about any contract-based claims such as specific performance for people who don't show up at closing, or confirmation actions or deficiency judge actions related to some amounts due on a note. So we are only going to be talking about conventional quiet title actions and quiet title actions against all the world. And yes, that's right. I said there are two different kinds of quiet title actions in Georgia. I don't know that we're the only state where that's the case, but it does tend to throw people for a loop because we generally talk about, or whenever I get a call for somebody saying, hey, I need a quiet title action, they are usually surprised to find out that there are still multiple choices to go, even once you've decided you wanted to go the route of a quiet title action. So what I'm going to try to do in the limited amount of time that we have today is to highlight this from both a transactional attorney's perspective. So if you are running title in a closing and you see that there has been some sort of title curative litigation that has happened in your back chain, I want to give the transactional lawyers a framework of how to look at what has happened and make sure that they understand what impact that has on the title. Or alternatively, if you're reviewing title in connection with an upcoming closing and you have determined that it cannot close because of some title issue, this discussion may help give you some sort of framework for advising the seller in that transaction as to, why you can't close, and maybe push them in the direction of what they need to do to get their title cleared. And then from the litigators' perspectives, or the aspirational litigators, it will be a I'll call it introductory primer on how these actions work, how they're supposed to go, highlighting some of the differences between the two actions to help you think through some, if you have to go one path or the other between the conventional quiet title action versus the quiet title action against all of the world, or if you've got both lanes open to you, some strategic considerations for you to think through as to which one might be better in your particular scenario. So I will say that if you have any questions, I've tried to time my presentation that I can leave some time open at the end. So if you have any questions, by all means, please drop them in the Q&A section. I'll try to keep my eye on them, but if I'm looking at my PowerPoint, I might not get to them until the end. So we'll just see how it goes, but certainly feel free to raise those issues as you see them. So with that going, let's just dive into it. Oops, hold on, there we go. All right. So let's talk about just the very foundational governing law and nature of the two actions and how they're different. You will see that both of the code sections are in Title 23, which is the equity title of the Georgia Code. So there is, so because they are both actions in equity, they are both going to have a mandatory jurisdiction within the Superior Court, since they have exclusive jurisdiction over issues of equity. The conventional quiet title code sections are codified at 23-3-40 through 44. So that is a very short, scant 5 code sections. They are not very detailed. This might be a good time for me to say that I've prepared a short paper in this in your materials, and it incorporates all of the statutes under both. So we are, so if you want to refer to any of those, they should be in your materials there. I will not be necessarily quoting from every code section in this process, or all I would be doing for the hour is reading you code sections. So again, only 5 code sections in the conventional quiet title is pretty short. It doesn't give a whole lot of directions. There is, whereas under the quiet title against all of the world is 23-3-60 through 73. So you can just tell by the number of code sections involved there, there's a lot more that makes this quiet title action against all of the world much more robust, but also conversely much more detailed in what you as the petitioner's attorney might be asked to do and to allege in your filings, and what documents you might need to include as an attachment to your filing. But foundationally, I think the biggest distinction for you to know in looking at these are kind of what the action is, or what the nature of the action is. A conventional quiet title action is what you can go back to your Civ Pro first year of law school terminology, for those of us that can still remember that. It is an in personam action. That means that it is like a regular civil litigation. It is the plaintiff or the petitioner versus the respondents. So it will only resolve issues as to any title interest in the real property maintained by those people who are specifically named as a party in the action. Conversely, a quiet title against all of the action is an in rem action, and that means that the property itself is your primary named defendant. So it is going to be binding not only as against the people who were specifically named in the action, but also the property itself. So that's why you get to the title of a quiet title against all of the world. It covers everybody, not just the discrete title issues that might be implicated in a conventional quiet title action. And also, this is probably where we start to get into the strategic practice tips for the litigators. You might want to think about venue. I mean, we've talked about jurisdictionally, both have to be under the filed in the Superior Court, but in terms of what county, you might want to stop and think about that. So in an in personam action under conventional quiet title, you need only file it in your regular Civil Practice Act rules. Where does the defendant reside? Conversely, a quiet title against all of the world is required to be filed in the county where the land lies. So, I guess you can think about that, where are you located? Is there something that is a particular benefit or maybe just convenience to you as the lawyer that you're, it's nearby, you're not going to have to travel if you're, say, in up in North Georgia in Dade County, but you're litigating a property down in Savannah and Chatham County that you may not want to be racing down, 75 and 16 trying to go to Chatham County for your hearings. But also maybe it's a point of convenience for your client or inconvenience for your respondents, if that's what you're looking for. Or you may just have a notion that, my local judges really understand title issues. I'm happy to have them be the ones looking over this. So let's go there. Or that I know all my judges are former prosecutors. They don't understand title issues. I think I can get a better shot in somewhere. So you might want to consider your venue options whenever you're thinking through which kind of action you want, to the extent that that's going to, that if they're different. I mean, it may be that all of your parties are going to live in the same county where the property lies anyways, and that won't make a distinction. But, and then the next practice tip or strategic consideration is whether you are desperate to avoid a jury trial, or if you think that a jury trial might really be helpful for you because of the salacious nature of your facts or the sympathetic appearance of your client, or you just would prefer having your chance with a bunch of strangers than with a judge. In a conventional quiet title action, there is no right to a jury trial. In a quiet title action against the world, the parties can make a jury demand. They're not required to, but you do have that option open to you in a quiet title against all of the world. So next, let's talk about what kind of issues can be addressed in a quiet title and in the respective types of quiet title actions, because this may actually dictate that you have to bring one form over the other. A conventional quiet title action, I sort of alluded earlier that it's what I would say more limited in scope in what it is designed to and can respond to. So in a conventional quiet title action, you can only bring that action to involve kind of two types of title issues. One is, removing a document which casts a cloud on title or where that document subjects the petitioner to some sort of potential future liability or present annoyance. So it has to be document based. So, if you've got a divorced couple where the marital property was in Cobb County, maybe there was a divorce decree that required that the husband quitclaim his interest in the marital residence to the wife, but he never did it. And then he's moved to Henry County. So In a conventional quiet title action, I mean, that's a document. There is a deed on record, presumably, where title came into husband and wife. And because the husband never complied with the orders of the divorce decree, there's never been anything on record that shows that, wife is now the sole owner for that, and she can't refinance the house into just her name until she gets that cleared up. I mean, yes, she may have options through the divorce action to file some sort of contempt action, but if he's gone silent, she can't find him or something, she might want to do it as a conventional quiet title action. There is a document there, that warranty deed that puts the husband's name on title, that she wants to clear up. The second type of claims that you can address through a conventional quiet title is addressing equities of redemption arising under a tax deed. And so that can go either way, whether the tax deed holder is trying to claim that they've adequately foreclosed all redemption rights and they're looking for fee simple title, or if somebody who's trying to enforce a redemption right wants to bring a quiet title and compel the acceptance of a redemption, or if they've redeemed but they haven't gotten the requisite deed to reflect that, they can bring a quiet title action to establish that kind of issue. And that's really it. That's all you can do for your conventional quiet title, which is not to say that that's not a lot, but and you can do all of those same things in a quiet title against all of the world, but then all of your other types of claims can be addressed through a quiet title against all of the world. So like your adverse possession claims, perhaps, that that would be not document based, but it's based on acts of possession. Or if you've got, what's another kind of non-document based claim? An oral contract for a will. That's a cause of action that exists in Georgia. But you've got an oral contract and not the will there, where you're trying to say, like, I was supposed to, I agreed, I went in and took care of my aunt and uncle. They promised me that they were going to give me that they were going to convey the house to me whenever they died. I can't find the will, but I had an oral contract. I provided these services for them with the expectation that I was going to get to that property. In that kind of situation, you would only be able to go through a conventional quiet title action if you were choosing between those two actions, because it's, again, not document based. I didn't put this on the slide, but another consideration that might force you in one lane or another is if you've got a governmental entity involved. So if one of your respondents is the city of Atlanta, for instance, the government has a sovereign immunity defense as against a conventional quiet title. So if you're trying to litigate against the government, whereas they do not have that same sovereign immunity defense against a quiet title against all of the world. So that may actually push you into doing a quiet title action against all of the world if you are litigating against the government. So that's another consideration. Let's see. Next up. All right. So I indicated that the quiet title action could be a little more onerous. And which is not to say that it's rocket science and you can't do it, and that there should be any sort of gatekeeping, and that a quiet title action is harder. It's just you've probably got more things on a checklist that you need to check off whenever you are filing your quiet title petition. So in a conventional quiet title action, the statutes really don't give you any guidance on what your petition has to say. You would just basically be subject to the same form of notice pleadings that would be involved in in any kind of civil action. Conversely, a quiet title in a quiet title against all of the world, those code sections give a very specific list of minimal things that you must set out in your petition, both in terms of allegations and in terms of attachments to them. First up, your pleading has to be verified. So the petitioner has to be able to attach some sort of verification affidavit asserting, in a notarized statement, that the facts and allegations contained in the petition are true and correct to the best of their knowledge. So you need to have that at least basic threshold. There needs to be a legal description of the property that you are trying to assert a claim on in that quiet title petition. You might have a lot of these in your conventional quiet title action, but you have to have them in your petition to quiet title against all of the world. You also have to specifically set out what is the petitioner's interest in the land. Is it a freehold interest? Is it a life estate interest? Is it, fee simple interest? What is it that you're trying to establish in the petitioner? And then you also need to state what their interest is based on. Is it based on some, a deed, a will, some written instrument, acts of possession, in the case of an adverse possession claim, or, in that oral contract for a will that I talked about, that there's, some oral agreement that you're seeking to enforce. So you've got to be very kind of clear about what the nature of your claim is. But you also have to be very clear about what the nature of your adverse claimants are. That if you think you think there's a forgery that's in there that they're claiming some interest under, you need to be very descriptive about what it is that those people's how their interests arise, and you also need to include a list and addresses of all those adverse claimants known to you. And so it should be inclusive of any and all adverse claimants of which the petitioner has actual or constructive knowledge. So maybe this goes without saying, but I don't want to assume anything. If you're going to be bringing really either type of quiet title action, but for sure a quiet title against all of the world, since you are charged with constructive knowledge, you should be running a full 50-year title search prior to bringing the action. So that way, anybody, and I will tell people all the time, if they come to me saying, I want to file a quiet title action to resolve this particular issue, like maybe it is I'm representing a tax deed holder who has waited the year, they have foreclosed the right of redemption, and they just want to go forward and clear that. We can do that through a quiet title against all of the world or a conventional quiet title, and that's fine. And I might have a very detailed discussion with my client about the pros and cons of each. But it's always going to be my recommendation to them that let me run, yes, you ran some limited title search for purposes of doing your foreclosure of the redemption rights. Let me run a full 50-year title. So that way, if we're going to be doing a quiet title action, let's know what all the title issues are. Don't make me have to go back to the superior court to relitigate something else. If you're in for a penny, be in for a pound. And so if they don't want to do that, I make them put it to me in writing, that they understand, but they just want to go forward on the limited issue that I have presented to them. So you also want to, so those are the things that you have to set out within the body of your petition, the description of all of those interests. You're also going to want to, or not want to, have to include certain attachments. And that includes a plat of survey of the land. Now, depending on the nature of the title claims, if boundary lines aren't really at issue, if locations of certain improvements or easements isn't part of your issue, then, like it may be in that divorce situation where the wife's really just looking for a quick claim deed from the husband pursuant to a divorce decree. You might see if you can just get away with a copy of the tax map rather than having to go and pay for a survey whenever the issues that might be raised by a survey wouldn't come up. But again, there is that sort of in for a penny, in for a sound, in for a penny, in for a pound. If you're bringing a quiet title action, maybe you want to do that full dive and make sure that there's nothing else that, you want to address while you're in there dealing with the specific issue that you have to deal with. And then lastly, the quiet title against all of the world statutes require that you file a notice of lis pendens in the real estate records where the property lies. So again, be mindful of your venue actions. If you've brought the action in Henry County because that's where the husband lies, but the property is in Cobb County, you're still going to need to file that lis pendens in Cobb County. the conventional quiet title action doesn't actually talk about lis pendens, but I would say under the lis pendens statute itself in Title 44, you're going to need to file a lis pendens in your conventional quiet title action as well. One last thing before I leave this thing. All of these actions, all of these statements that have to be done on the quiet title against all of the world, if you fail to do that, those are amendable defects. So if you did not realize at the time that you didn't attach certain documents or you didn't include certain recitations, you can always amend to add those later. You wouldn't be subject to a motion to dismiss unless you just failed to cure the problem. All right, let's talk about special masters. This is a big strategic consideration or motivating consideration for people in going in either which way. And I guess I'll stop real quickly and acknowledge that I know that there was a lot of discussion a week, maybe 2 weeks ago on the real property sections listserv about special masters in the code sections, and some folks desire that maybe there needs to be some amendments to that. That's kind of beyond the scope of what we're talking about today. I'm just going to be talking to you about what the code sections as they exist right now provide for, and if we get an amendment in the future, maybe Stuart will have me back. But we're not getting into sort of theoretical or potential problems with it. This is what the rules are, and you can make your decisions accordingly. So in a conventional quiet title action, whether you or not you have a special master, and we'll get into what a special master is and what their roles are here in a minute, but whether you have one at all is entirely at the option of the party asserting the quiet title claim. So whether that be a quiet title petition or whether it's a defendant has brought a quiet title action, quiet title claim as a counterclaim, whoever is asserting the quiet title claim, that's who gets to decide whether or not they want to have a special master. If a judge appoints one over that party's objection or where they have not requested one, the Court of Appeals, I think, or one of the appellate courts has determined that that is reversible error. So the judge can't push you into a special master scenario where you don't want one in a conventional quiet title action. And similarly, the parties who are defending the quiet title action cannot force that issue. Now, if a special master is appointed in that quiet title, in a conventional quiet title action, that the statute refers you then to the quiet title actions against all the world, the specific code sections that deal with the duties and the role of the special master and how those proceedings work. So if you're bringing a conventional quiet title action where there is going to be a special master, you will still need to familiarize yourself with the rules governing special master appointments. But however, in a quiet title against all of the world, it is mandatory. You have to have a quiet title action. I mean, you have to have a special master, whether you want one or not, and whether the judge wants to hear it or not. It's still got to go before a special master. So let's talk a little bit about how those proceedings before a special master work. Well, what is a special master? And this was part of the debate that was on the listserv recently that says, about what are special masters and or why they want to change some of the special master code sections. And so all it has to be right now, as the law exists, is that it is somebody who is admitted to practice. So it is a lawyer in good standing with the state bar, and that they be a resident of the judicial circuit in which the case is brought. And so again, if you're talking about, that maybe let's just go back to that husband and wife divorce wife if it was a conventional quiet title where the wife sued the husband in Henry County and she elected that she wanted a special master, you'd have to select a special master that resided in the, I don't know if Henry County is a single county circuit or not, but that regardless resided within that circuit. if she was bringing a quiet title action against all of the world, her property would be, her action would be in the Cobb County Superior Court. I believe that, I am pretty sure that is a single county circuit. And so her special master would have to be a resident of Cobb County. So like, I'm a special master. I live in DeKalb. That's the Stone Mountain Judicial Circuit. It is a single county circuit. So I can only hear quiet title actions that are brought in the DeKalb County Superior Court, whether it be conventional or quiet title. So how does the special master become involved? Well, the judge has to appoint the special master, be it in a conventional quiet title. The judge can just do it at his or her own behest. Again, in the conventional quiet title, it would be at the request of the complainant. And the judge has the ultimate decision as to who's going to serve in that role. They may have special masters that they like. They may have a list of people that are approved to serve, or they may just take a request from the parties that we want this individual to serve as our special master. And there is no requirement in the statute that requires that they've been in practice for a certain number of years, or that they be a member of the real property section, or that they have any specific expertise. But that is certainly the idea, is that you've got somebody that, you've got Superior Court judges that hear all manner of things, your criminal cases, all of your civil cases, domestic, etc. The idea is that a special master should have, hopefully, that sweet spot of litigation expertise, since they are overseeing a litigated matter, but also some sort of understanding of the title issues that makes them especially well equipped to oversee these kinds of proceedings. So once the special master is appointed, again, it's going to be by court order, then what does the special master do? Well, the first thing that she's supposed to do is take all the evidence from the petitioner, the pleadings that have been filed to date, if there's any evidence, and they're supposed to look through that as a separate, independent set of eyes and make a determination of entitlement to notice. So what they're doing is they're looking through, and they may require that the petitioner file an abstract of title. Many special masters will go out and get their own separate title reports, just to make sure that they've got an unbiased report of what the title says. They may undertake some additional research and probate records, or the Social Security Administration, like death index records. They can do as much or as little independent investigation that they want, but they're going to then look at who is entitled to notice of these proceedings. And you hope, if you're the party that's brought the quiet title action, that the special master's list of the parties entitled to notice are going to line up with who you've listed as respondents. And most of the time that is the case. I mean, you might occasionally find, and I've certainly, as a special master, required parties or litigants to serve more parties that they did not name in their action. But hopefully you find that it matches, but you work that out. And then the special master can also, in looking at those same lists of defendants, if they have determined that there is a party that is a minor, laboring under some sort of disability, a person not in being, that they're unascertained or unknown, the special master can make a determination in those situations that if somebody that falls into one of those categories has an interest or might have an interest in the real property, then the special master can appoint a guardian ad litem to be appointed for the purposes of protecting those categories of interests. But then once all that's done, the special master then causes process to issue. So that means they're basically overseeing the service of the action, making sure that the petitioner is serving everybody that they need to, that they have, if they haven't been able to personally serve, that they've exhausted all the reasonable diligence to make sure that proper service was at least attempted before you get to a service by publication situation. And that's really why you'll find that a lot of title insurance companies have a distinct preference for either a quiet title against all of the world, or a conventional quiet title where there was a special master. And that's because they like the feeling that there is a separate set of eyes that's looking over this, that they sometimes feel that a Superior Court judge may be kind of rubber stamping things and not looking over things as closely as they need to be. But once all of the service has gone out and all of the evidence of service has been filed with the court, the code sections say that the special master then has complete jurisdiction within the scope of the pleadings to ascertain all matters pertaining to title. So that's pretty broad. So the special master can then, and really kind of only once all of that service is completed, determine the next avenue of the case. So people can file motions. The special master can hear motions for summary judgment, other sort of dispositive motions. The special master can conduct a bench trial, just an evidentiary hearing on the matter. If somebody wants to make a jury demand, the special master can oversee that. The special master also has the power on his or her own initiation to require that there be a jury trial. I've never had a special master do that over anybody's objections, but that's certainly something that can happen. That's kind of how the preliminary actions happen before a special master. And then whatever the ultimate resolution of the case before the special master is, whether it's a jury trial, a bench trial, or some sort of ruling on a dispositive motion, the special master, like I said, has complete jurisdiction, but they don't have final jurisdiction. At that point, the special master punts it back to the judge, usually with a report, a special master's report that contains findings of fact and conclusions of law, or perhaps the jury verdict if there was a jury trial, and basically tells the judge, you appointed me, this is what I did, we had a hearing, these are the facts as I find them, based on these facts, this is what I believe the applicable law is, and these are the conclusions that I believe that title should be vested as of however. It's ultimately up to the judge to adopt the special master's report or not. Also, the special master, unless the parties maybe agree or stipulate otherwise, the special master is really only going to be hearing those quiet title and title-based claims. So if you have a situation like maybe two neighbors that are fighting over a boundary line, and one neighbor is saying, for the last 20 years, I have been planting and cultivating this area, and I've now owned this 20-foot stretch by adverse possession. And maybe the other side has, counterclaimed and said, no, you don't. And, I'm also bringing a claim for trespass and damages because you're squatting on my land. So the special master in that situation would probably hear the title. You would have a bifurcated trial in that scenario. The special master may hear the title issues, and that can be helpful to do that first anyways, because if the person who's claiming adverse possession prevails, then that may make the counterclaim for a trespass moot, for instance. But nonetheless, it's something that you want to make sure that you're thinking through in terms of if there are multiple claims, what a special master can hear versus what they can't. And does this mean that I'm going to have basically two trials, and make sure that you're, in that case, do I want to have a quiet title action at all? Maybe I prefer to have, if this is something that I can bring as a declaratory judgment action, I want it streamlined. I don't want to have to be going through all of these different machinations and different proceedings. So that's something that you might want to think about. Now, the special master is entitled to charge for his or her time. Statute just says it's going to be an amount more than $50. I guarantee you it will be more than $50. But your mileage may vary depending on who you get as your special master, obviously how contested the case is, whether or not you're in a metro area and what local rates are there. So that's another consideration that you may want to think about whenever you're bringing, whether or not you are going to bring this in a manner that requires a special master. In terms of who pays that, both the guardian ad litem's fees and the special master's fees are assessed by the court. So typically the special master is not paid until the end unless they make some sort of interim request for payment by from the court. But the judge is going to look at whether or not the special master's fees are reasonable in light of whatever's gone on in the case, and same thing with the guardian ad litem's fees. You know, how many hearings did you have? What all for the guardian ad litem, what sort of investigation they may have had to have done to determine what, if any, interest that the parties that they are being the guardian of may have. And then the judge tax those costs against the litigants. And there is no default here. I mean, in an uncontested case, you know, certainly I would imagine that the petitioner is going to pay 100% of those fees, but there's no rule that the person who gets the property prevails. So you're open to arguing, and I certainly have argued, especially in a contested case where there's a lot of special master's fees at stake of, you know, this person was acting in bad faith. They caused the same thing like you would in a fees motion, that they've caused an expansion of the proceedings, and that therefore they should be responsible for the special master's fees. But that's all ultimately going to be up to the judge, and it's 100% a discretionary act or discretionary decision by the judge as to how to allocate those. So let's see, what else have I missed on here? Like I said, the judge is going to enter the final order. It may be something as short as a 1 or 2 page order that just adopts the special master's report as the order of the court, and it incorporates it by reference. You can, if you don't like the way the special master handled the case, or maybe not handled the case, but the way that the special master made his or her recommendations to the judge, you are entitled to object to those. You do not have to do it. There's no requirement that if you're ultimately going to appeal this case to the Court of Appeals, you don't have to, as a precondition, have objected to the special master's reports, but certainly you can. And then there is, so then the judge can do what he or she wants to do with those objections. It can, you know, review them and then decide to adopt or have or not. They can have a hearing on those. The judge could decide if he wanted to, probably unlikely, but just have a whole new trial that they don't think that they thought the special master was completely off. But just know that is an option, but certainly not a requirement. So you've got your special master has made her report back to the judge. The judge has entered their final order that presumably would adopt in most cases, would adopt the findings of the special master. So what you get, that final order is usually entitled a decree of title. Well, it doesn't have to be, there's no magic words to that. But what do you do whenever you got it? Where does that put you? So in a conventional quiet title action, you certainly want to make sure that you record it in the deed records, cross-reference it to any documents in the chain of title that might be impacted by that title litigation. So if you were saying that there was a security deed that had been paid off, but there hadn't been a cancellation, maybe the bank failed and you can't find somebody to issue a cancellation of the security deed, you want to make sure that you cross-reference the order to the security deed, so that way anybody who's picking up title later can make sure that they pick up that. Or if you're reforming legal descriptions in any deed, every deed in the chain of title that had left off that call that you reformed, you want to make sure that each of those get cross-referenced to the order. Now, one note in your conventional title, remember that you've got, your standard venue rules. So if you're litigating against the husband in Henry County, you're going to need to have that extra step and make sure you go to the Henry County Superior Court clerk, get a certified copy of that final decree of title and potentially the special master's report. And then you take that back over to the Cobb County clerk so they can record it in the Cobb County real estate records. Just like in regular civil litigation, a quiet title action, conventional quiet title action is subject to a 30-day right of appeal. So if you are a closing attorney and you are asked to close on this property immediately after a quiet title was wrapped up, I can pretty much tell you that every single underwriter in the state is going to tell you, you are not clear to close until that 30-day appeal period has passed. And so you also want to make sure that your examiner is looking in the civil records whenever they have found that final order, because if the loser in that action has filed a notice of appeal, then obviously your case is stayed, it's still ongoing, it's in the appellate courts. They may not think to file anything in the real estate records. So you want to check the civil records and confirm more than 30 days after the issuance of that final order that in fact the appeal period has passed without anybody filing that notice of appeal. And then a conventional quiet title action, it has the same finality as any sort of final order in any civil case, just with the note that it is only binding as to the parties that were actually named in that lawsuit. Now, quiet title action against all of the world, conversely, it is same thing. It needs to be recorded in the deed records. Same thing as the 30-day appeal period. There are two kind of additional points. There is a right to you can intervene as a matter of right in a quiet title action if you were not named and but you are nonetheless claiming some interest in a quiet title in this quiet title action. I mean, of course, the Civil Practice Act has its own rules as to intervention in any regular civil action, which would be inclusive of a conventional quiet title. But since this quiet title action against all of the world is in rem and it is so inclusive of everyone, the General Assembly has decided to have its own intervention statute that you don't have to go through all of the showings that's required under the Civil Practice Act to show that you should be allowed to intervene. You can just claim that you have an interest in the property and you have that right to intervene. And that 30-day right to intervene continues to exist until 30 days after the entry of that decree of title. So that's, again, another reason to check the civil records after this and make sure that no one has, and so if somebody does intervene after the entry of the final order, the case gets reopened for the limited purpose of adjudicating that intervenor's rights in the property. And then lastly, there is a provision within the quiet title against all the world statutes that says that recorded deed shall operate to bind the land effective and shall be conclusive upon and against all persons named therein, known and unknown. And again, this is where we kind of come back to a lot of the title insurance companies have a stated preference for this form of quiet title, the quiet title against all of the world, that they like that you have to have a special master. They like that you have that extra layer of oversight. They like the conclusiveness of the language in here. So if you are a closing attorney who is going to be recommending a quiet title action, or a litigator who's about to bring one, and you know that there is going to ultimately be a title insurer that is going to be asked to issue a policy upon the closing, the completion of this quiet title action, you would be well advised to familiarize yourself with any published underwriting guidelines that title insurance company has on quiet title actions, or in absence of having access to those, talk to your underwriter and see if they have a requirement. There are some title insurance companies that flat out will not insure a conventional quiet title action for any reason, that they want you to do a quiet title against all of the world. Some have a preference, but not a requirement. Others may say, well, let's look at the nature of what the title claims are and what they're comfortable with. So when in doubt, as with all title issues, we say this all the time in the title and standards seminars, is when in doubt, ask your underwriter. And while your underwriters probably aren't going to be litigators, they're still going to have a big opinion about what they're willing to insure at the completion of all of this. So that's always a good resource to look at. So that is the end of my prepared materials. I will, let me check the Q&A and see All right, so one question is, in an uncontested quiet title following a tax deed, what can I tell a client is a range of special master's costs? I try to punt that when I can, saying, I don't want to be in a position to quote what another lawyer's fees are. And certainly it can vary geographically. If you're outside the metro area, rates tend to be lower than in the Atlanta metro area. But I would say, in my experience, $1,000 is really cheap. Probably, in my personal opinion, if you're getting kind of in excess of 2,000, maybe 2,500 for an uncontested case, I mean, that's not to say that it doesn't happen, but that's probably still within the range of, I certainly wouldn't advise a client to object to that. You're not going to get anywhere with the judge, and it's going to cost you more money to object to that. But to that end, on a contested quiet title, all bets are off. I mean, you could be in the tens of thousands of dollars. So people just need to, not that you necessarily will be, but depending on how complicated the case is and how long it drags out, just like your own lawyer's bills, the special master's bills are going to climb up there. So that's something that parties really do there. Let's see. So then, let's see. Another question is, title insurance companies now require quiet title actions after tax sales, unless you can get a quick claim deed from the redemption right holders. But title companies are refusing to insure where there is any indication that the tax FIFA or tax sale was against a deceased former owner, which happens often, namely that the tax deed in that case is a nullity. Thoughts? So I can and have done whole presentations just on tax deeds. But my general answer is, whenever I get that kind of pushback from a underwriter in my case, is I'm looking at the underlying FIFA itself. Was it issued just in personam or in rem? Like, is it Douglas County, not to call out Douglas County, I'm not even sure how, I'm not positive how their FIFAs are issued, but is it Douglas County versus, Joe Smith? Or is it Douglas County versus Joe Smith and 123 Main Street? In which case, then the property itself is a defendant on the tax FIFA. And my contention has always been that in that situation, the FIFA attaches, that there's plenty of codes plenty of case law that talks about, and I can provide that to the title underwriter, that I don't think that the tax sale is bad. And your mileage may vary depending with your individual underwriter as to whether or not they find that to be persuasive, or they're just not going to do it. And of course, they may also look at, well, if it was in the name of a deceased person, but there was probate records that show that there was an open estate, or who the parties are, or did they list the tax deed coming out of Joe Smith and or estates or unknown heirs at law? There can be a lot of different permutations on the fact of a deceased owner that might be worth having a second go with your underwriter. And if there are any underwriters on this, I apologize if I'm sending a bunch of people to you with additional questions. But let's see. Then there's can you talk about the use of a declaratory judgment in removing a cloud after a tax sale? So, I mean, a declaratory judgment is just what it is. I mean, you're asking the court to declare something. So you could potentially frame a action. I typically do any sort of actions to clear a title after a redemption of a tax or foreclosure of redemption rights under a tax deed as a quiet title action. But if I guess conceivably you could do it where you're just asking the court to in fact declare that all redemption, that the petitioner, the tax deed holder, has followed the statutory mechanism to adequately foreclose all redemption rights, and that their fee simple title is vested in that tax deed holder. Let's see, is there anything else? Can you please elaborate on why sovereign immunity is not a defense in a quiet title action against all of the world? Because the Supreme Court says so. And I think that's it. So thank you everybody for your time. And I will make sure that Stuart and Lane gets a copy of this PowerPoint presentation. So I think anyone who wants it can certainly get a copy of it. So.
Great, thank you, Allie. That was really good. Yeah, there was a couple of questions about the slides. So I tried to answer the questions in the Q&A that I check on that. And so we'll work it out with Lane to send those out. But yeah, thank you for the presentation. And we're just up at almost 12 o'clock. And I want to just remind everyone that this is the third and final session of the 2022 residential seminar. The other two seminars were recorded and they are available on the section's website. The first one was Tour de Mortgage Finance by Jack Keeler, talking about how the money works back and forth amongst servicers, warehouse lenders, and all that. We had Bankruptcies on Title, Kenny Stroud with Caddick. We also had, I guess it was 2 weeks ago, Chad Hunt, who's a supervisory special agent with the FBI, but his presentation was not allowed to be recorded, so that one won't be on the section website. But we did also have the 2021 Alta Forms presentation 2 weeks ago, and that either should be on the website or will be up there shortly. And as Ali mentioned, the ICLE Institute is, well, actually it's a couple months away. It's in May, and hopefully everyone will be able to go and back in person again, and again for that. So we're just at 12 o'clock. So thank you again, Ali. Thanks to Sharon, Marcos, and Jane from earlier. Hopefully we'll see everyone soon, and stay safe and have a good weekend. Thank you.
This concludes today's webinar. Thank you for joining and have a great day.